Good morning, Mr. Elliott. Can you see and hear me okay?
Yes, Your Honor.
Okay, good. Mr. Leister, are you there?
I am, Your Honor. Can you see me at all?
Can't see you, no, sir.
Okay, let me.
Obviously, can hear you, though.
Well, that's a step in the right direction. I put a new camera on my system yesterday.
All right, we're getting something. There we go. Now we got it.
Is that?
That is. We're good to go.
All right. Well, I had to open my laptop as opposed to relying on the new camera system.
Okay. Are we expecting anyone else?
Mr. Sanders, I had talked to him, probably less than 10 minutes ago. I don't know if he got disconnected. I think he was waiting online at one time.
I've been logged in for a few minutes. I haven't seen him. So we'll just wait on him, and as soon as he pops in, I'll bring him in. Okay. So what I'm going to do is I'm just going to pause my recording here, and I'm going to step away real quick and run to my office, and then we'll see if he joins us. We'll give him a few minutes.
Thank you.
Good morning, Mr. Sanders. Can you see and hear me okay? Okay, and you're muted. You'll want to unmute that.
Yes, Your Honor. Good morning.
Excellent. Oh, okay, gentlemen, are we ready to proceed?
I believe so, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right, good. All right, court is on record and calls cause number 20-136 and 138, Terry Massie versus Boyd et al., we'll call it. And I believe that today's setting is for the defendant's plea to the jurisdiction in each case. And I understand that I've read the plea to the jurisdiction. It's my understanding, Mr. Leister, that you filed a response. I have not, I've heard about that. I have not seen it. I believe it was filed late last night is what my staff told me. So by the time it gets through e-file, it takes a while to get to me. So I have not seen that, but I have read the plea to the jurisdiction. So I guess Mr. Elliott, Mr. Sanders, who's going to be leading on the boys' behalf?
I'm going to start, Your Honor, and I believe after Mr. Leister responds, then I think Mr. Elliott's going to take care of the reply.
Okay. All right. Then if we're ready to go ahead, Mr. Sanders.
All right, Your Honor, I thought this was going to be a fairly short and quick hearing this morning because we've got a clear issue of federal law that says you can't sue your employer if your employer allegedly does not pay your withholding taxes to the federal government. But then yesterday at 5:15, they filed an amended petition. They filed a response at 9:30 last night. I was up till 1:30 researching and drafting a reply we have filed this morning. And it shows, Your Honor, that they know they're in trouble. So they cooked up some new allegations to try to get out of this plea to the jurisdiction. And they're not going to be able to do it because it's subject matter jurisdiction. Now, the first issue, the one that got all this started, is this allegation that my client, J&L Utility Company, and individuals with the company, and some that aren't directly related to the company, somehow took money from the employees' withholding and FICA taxes, didn't pay it to the federal government, took it for themselves. There's no cause of action for that. In their reply or their response, the plaintiff didn't explain at all how the Slodog versus United States case, and where it says, once net wages are paid to the employee, the taxes are withheld, are credited to the employee, regardless of whether they were paid, so that the IRS only has recourse against the employer. They didn't explain how there's anything vague, wrong, outdated with that case. They didn't explain how the Fifth Circuit's rulings in Newsom and Mazzo that says the exact same thing, that it's trust money for the federal government, the employee gets credited for it, did not explain to you, Your Honor, how that's in any way wrong. Did not explain how 26 USC 7501 that says that money held in trust for the federal government, how that is somehow wrong or outdated or fake. They didn't do anything. The only thing they did is they tried to argue that there's still some kind of private cause of action under the tax code and FICA. And once again, just like he did at the last time we were in front of you, Your Honor, where Mr. Leister was saying to stay an injunction hearing based upon a Fifth Circuit case, he's arguing old law. He's done it again. He cites all of these old cases that predate two circuit cases, the Umland case and the McDonald case, that say there is no private cause of action. So at this point, it's clear he's not either not reading the cases or he's ignoring them. And what's hilarious, Your Honor, is, and I say hilarious, it's not really that funny if you're my clients. In one breath, he said in his response, there's a private cause of action. And then he cites the McDonald case, which says there's no private cause of action. It goes through that court analysis and said, no, there's no private cause of action. So he's graduated from not reading the cases I cite to not reading his own cases. And there's no explanation, Your Honor, about what is vague, wrong, or outdated with the Glanville case, which was written by Judge Rosenthal down here in Houston, the chief judge of our federal district down here. The Chandler versus Perini case, where the court said this kind of cause of action is statutorily barred. You cannot do it. Then Kramer versus Javits, a state court case, where somebody tried the exact same caper that these guys tried, and the court said no subject matter jurisdiction. So at the very least, Your Honor, you can get rid of the original causes of action that they provided. The new claims that they brought, you can still bounce today because subject matter jurisdiction is never waivable, and it always can be raised by the court sua sponte. So if he doesn't have standing, if Mr. Massie doesn't have standing to bring any of these claims under his pleading, then you still can dismiss them. I don't have to file yet another motion in order to get rid of claims you don't have subject matter jurisdiction on. The first thing they claim in the response, they say they filed a claim for breach of the common law duty to provide a safe workplace. The problem with that is that's a personal injury claim. That's a negligence duty. They didn't sue for negligence. They didn't sue saying that they were for injuries that they sustained as alleged because they had some kind of failure to get safety equipment. And the reason why they didn't assert that claim is because they know that they'd be barred by workers' comp. So that claim would have been dead. Even if they'd actually pled, Mr. Massie did not plead that he, not other employees, but he specifically had been injured as a result of not having safety equipment. Without individual standing, a class action plaintiff cannot proceed. The next claim that they threw in is they added to their conversion and theft and conspiracy claim, claiming that the employees had deductions taken out of their checks for safety equipment that was provided. The problem with that, Judge, is that's a wage and hour claim. That's an FLSA claim. Deductions for safety equipment are only improper if they result in the employee not being paid overtime or minimum wage. Mr. Massie does not allege that as a result of a deduction from his paycheck that he was not paid either overtime or federal minimum wage. That would be an FLSA claim. You don't want to file that because then they could sue Boyd's individual. So he doesn't have standing to bring that claim. The last thing that they dreamed up last night is that somehow employees were lured into remaining with the company based upon a bonus, a promise to have a Christmas bonus. And again, Mr. Massie's pleading does not support individual standing. Their argument is, well, we would have left the company, people stayed with the company, they were going to leave the company, but then when they promised a bonus, Christmas bonus, they stayed with the company. Well, for Mr. Massie to have individual standing on that claim, he would have to assert in his pleading that he, in fact, stayed with the company because of that bonus and gave up, and he was damaged by giving up another employment opportunity that he could have taken and they would have taken had there been no promise of a Christmas bonus. So all of the new claims that they think get them out of this plea to the jurisdiction, you can bounce today on subject matter jurisdiction. And Your Honor, the only way that this crew is going to stop filing this kind of garbage in your court and polluting this court with this kind of nonsense is if they're sanctioned. Because otherwise, I mean, they're going to come up, you throw these claims out today, the next thing they're going to do is file like I don't want to give them too many ideas, but this is kind of ridiculous stuff they'll come up with. Well, intentional infliction of emotional distress, because, you know, at some point, Mrs. Boyd looked at this guy funny, and somebody else said a bad word. That's the kind of garbage that they will keep coming up with unless you sanction. So we ask that you grant the plea to the jurisdiction in both cases and set this matter for an evidentiary hearing. And last time we were there, I said I wasn't available the week of October 19th. I'm available now. The trial got canceled, so I'm good.
All right. Thank you, Mr. Sanders. Mr. Leister, you want to respond?
I do, Your Honor. Your Honor, earlier today, we had emailed Miss Barker the pleadings that we had filed, the response to both pleas to the jurisdiction. Despite Mr. Sanders' enthusiasm, there is a split of authority in terms of whether or not a private right or a private right of action exists when an employer takes and uses an employee's FICA wages. And that's in fact cited in our response. There is not a circuit case, nor is there a United States Supreme Court case that frankly deals with that issue. The analysis that the court will be obligated to undertake arises out of a case from several years back called Court versus Ash.
Can you repeat that, Mr. Leister? You kind of trailed off. What just the case site?
Court versus Ash.
Thank you.
And it is a United States Supreme Court case from 1975, 422 U.S. 66. In that case, it was a different issue, in other words, it did not involve FICA. But what it did involve was a court doing an analysis where there's not an express private cause of action created in the statute. And what the U.S. Supreme Court did was they set forth this four-part test that courts are required to go through in order to make a determination as to whether there is an implied private cause of action. And the four-part test is, in essence, first of all, is the plaintiff one of the class for whose special benefit the statute was enacted? Second, is there an indication of congressional intent to create such a remedy? Third, is a private remedy consistent with the underlying purposes of the legislative scheme? And fourth, is the cause of action one traditionally relegated to state law so that an implied right of action is inappropriate? And I cited in our response a number of cases, federal cases primarily, wherein those courts determined that a private cause of action exists for an employer taking and using FICA wages. The most, I guess, the two that I cite specifically to in there are the Sanchez case and the Ford versus Troyer case. The Sanchez case is a case that came out of the Northern District of Ohio, 45 F-Sup 1178, 1993, and the Ford versus Troyer case is a case that came out of the District Court of Louisiana in 1988. Its location is 25 F-Sup 2nd 723. Both of these cases had their origins in what you would call employer or employee misclassification. In other words, there was the origin, if you will, of the dispute had to do with whether or not the individual who brought the case was an employee or was an independent contractor. The employer took the position that they were independent contractors. They did not have an obligation to pay, withhold FICA wages. That's kind of a tangential issue to the key issue here, which is whether or not a private cause of action is implied in the statute dealing with FICA. I'd like to visit about the Sanchez case first. That particular case, the court acknowledges that there's not an explicit cause of action provided in the FICA test, and then went on to do the Court versus Ash four-part test to make its determination. And in that particular case, the court said, as far as the first factors set forth in Court versus Ash, whether the plaintiffs were part of the class for whose special benefit the statute was enacted, the court then looked at the purpose of the Social Security system. And in looking at that, it made the determination that the Social Security system was instituted to create a trust fund to benefit workers upon disability or retirement, and to establish a system of federal old age benefits. The court there went on to state, Mr. Massie is here, on behalf of the
And sorry, Mr. Leister, go back. I need you to start back to where you said the court went on to say.
The court went on to state there, and looking at that first Court versus Ash factor, there was little doubt that the plaintiffs were members of the principal group and FICA was enacted to benefit, i.e. workers of the United States. Going and looking at the second factor from Court versus Ash, congressional intent. The court there, in the Sanchez case, went on to state that you don't necessarily have to go back and look at the legislative history to determine whether or not that provides support for a private right of action. The court went on there in Sanchez to state that it can be, there's just no doubt in their mind that when even though the statute was silent on congressional intent, that the legislative intent could be determined through examination of the structure and the language of the statute or the circumstances surrounding its enactment. On that basis, the court reasoned that the relief the plaintiff was seeking was consistent with the purposes of FICA and the circumstances of its passage. The court went on to say, and I quote, "Since working men will not be able to draw Social Security upon their retirement unless they and their employers have contributed to the fund during their working years," then the court said it was of the view that a private right of action was necessary so that workers properly classified as employees could compel their employers to correct their earnings records and make the required and correct contribution to the FICA trust fund. There are two other factors, the third and the fourth Court versus Ash factors. In Sanchez, the court also determined that both of those were met. In Ford versus Troyer, which is the primary case that we cite in there, out of the Eastern District of Louisiana, the court adopted the same analysis that was set forth in the Sanchez case in determining that an implied right or an implied right, a private right of action was able to be brought by an individual in exactly the same manner as Mr. Massie brings it in this case on behalf of himself and on behalf of others similarly situated, whether they were working for J&L in the one case or whether they were working, and that's the 136 cause, or whether they were working for Jagged Edge, which is the 138 cause. So there's a split of authority, and I know Mr. Sanders goes, well, look at my cases, they're newer, but certainly the cases that I cite have not. There is no Fifth Circuit on point that deals with this. There's no United States Supreme Court opinion that deals with this particular. The court's going to have to make a determination. It's certainly not sanctionable, as Mr. Sanders would allege, that my client has brought a cause of action where there is a split of authority, and there just is. The court's going to have to figure that issue out and analyze the cases provided by both sides, and reach its own determination as to whether or not Mr. Massie has a private right of action of these cases for for the violations of the FICA, that basically the stealing and using by the defendants in each case of the employee contributions to FICA that were deducted from their payrolls. Now, as it relates to the other claims or other causes of action in the J&L case, which is 136 case that were amended yesterday, Mr. Sanders raises issues about those, and I don't think those are before the court today. And as I was listening to his argument, they did not appear to be one of a standing type issue. It appeared to be more something along the lines of a special exception, but I realize those are not set for hearing today. But at the end of the day, the claim as it relates to the breach of the duty to provide a safe working environment, Mr. Sanders is correct. This is not a comp claim. No one in this case is alleging an injury. What they're alleging is that the employer had a duty to provide safety equipment, and when they made their employees either buy it or they deducted it from their employees improperly, that damaged employees to that amount of money, whatever it was that they ended up having to buy. Mr. Massie has had to do that. Others have had to do that. That's not, no one is claiming a comp injury. It's an economic damage as a result of the employer's breach of their duty. But I don't think that's a standing issue. That might be a summary judgment issue. That might be a special exception issue. That's not a standing issue in terms of their ability to bring that claim. And the same for the employee bonus fund that was created, which induced and enticed people to continue to work there. At the end of the day, Your Honor, you're going to need to figure out and look at the cases and determine which analysis you believe to be correct. Either the cases cited by Mr. Sanders or the cases cited by us in terms of whether or not an implied private cause exists as a result of the FICA claim, both the 136 case, which is the J&L case, as well as in the 138 case, which is the Jagged Edge case. Your Honor, we believe that when you do that analysis, you will reach the same conclusion as the courts in Sanchez and the courts in Troyer and the other cases that are cited in our response. And you'll allow this case to go forward. Certainly, at least, and we're not even to the point where, I mean, these cases are brought as putative class actions. This is the very first shot out of the bag, not even gotten into discovery.
Hang on. Say that again. You said you cut out again. Can you go back to where you said, I heard you say, first out of the bag, and we haven't even gotten to, and we lost you after that point.
Thank you, Your Honor. This is the first shot out of the bag. These are putative class actions. We've not gotten to the point where the court has had to consider and address whether or not to certify a class or things of that nature. What I'm in essence saying is this is actually too preliminary at this point in time to consider this issue. The court is going to consider the issue. I think it's going to consider it later on. But if the court does decide to consider it at this point in time, I think the appropriate analysis is the analysis set forth in both the Sanchez and the Ford versus Troyer cases that are cited in our responses in each case, which would mean that the court should determine there is an implied private right of action, deny the plea jurisdiction filed in each case.
Thank you, Mr. Leister. Mr. Elliott, do you want to respond at all?
Just briefly, Your Honor, the plaintiff is speaking that there's division among courts. There's not a division in courts. The law is very clear. What we're actually talking about is apples and oranges. In this matter, in the cases that they cite, there's a big difference between dealing with the withholding of FICA issue and the declaratory judgment that was being sought among an agricultural community where there's a conflict between was there an employee relationship, or were these contract workers? That was the issue in the cases they're talking about. The cases we're specifically talking about, you can go to the I believe Kramer versus Javits case that we have, it is spot on. It is specifically talking about, and we're not talking about contract labor versus employer relationship. As pled by the plaintiff and undisputed by the defendant, there were J&L Utilities. They had employees. They may have had other contractors or contracts with other people, but with the people bringing the suit, they were employees. And what you're looking at is there was withholding of FICA, and there was an allegation that the FICA was not paid to the U.S. Treasury. Clearly, in the cases that we cited, it says that common law defenses, or excuse me, common law allegations, claims that are brought in state court are barred by the the U.S. tax code. The U.S. Treasury can bring action to recover, and exclusively can bring an action to recover these funds that are being held in trust. The case that Mr. Sanders specifically referenced said once a paycheck is issued, a net paycheck is paid to an employee, and those funds are held by the employer, paid or not paid, that employer is holding it in as a trustee in a fiduciary role, not for the employee that they claim, but for the U.S. Treasury. And the case specifically says the employee never has standing in any way to seek those funds. A couple of reasons is there's a statutory bar on that against those common law allegations the plaintiff has made. But secondly, there's no damages. They have no standing for that reason because those aren't their funds. Those are the U.S. Treasury funds if they haven't been paid. They're not damaged. The case specifically says, our federal law says if I'm an employee and you are my employer and you withhold those funds, the U.S. Treasury is going to give me credit for that no matter what, whether those funds never existed. But if they were withheld out of my paycheck, I get credit for that. It goes on to say it has zero effect on what Social Security they would earn later. Zero effect. There's no damages. Without damages, there's no standing. That didn't even address the issue about the statutory barring. And if you read that case about the statutory barring, what I like about that is they address every element. That it's almost like the plaintiff went to that case, ignored the ruling, pled everything that that plaintiff pled: breach of fiduciary duty, conversion, all those things. Judge, most of what has been said today doesn't even have to do with standing. What has been argued is, as an individual, can I do a class action suit? I don't think anybody would disagree that if you don't have standing as an individual, if you're statutory precluded from bringing a common law claim as an individual, if you can't exercise that right because it doesn't exist, you don't have standing. If you individually don't have standing, this goes back to law school. If you don't have individual standing, the class has no standing. You can't file on behalf of a class if you don't have individual standing. Now, Judge, just real quickly, there was 5 cases that Ms. Sanders provided to you. The Sludo versus United States, the Supreme Court case. That's really easy to address or summarize that. Basically, in that, federal government gets to go after the employer if there's a claim. The second case, which is the MD Anderson case. The good thing about MD Anderson case, that specifically addresses standing. It basically states that a prerequisite, basically you got to have standing as an individual to have standing as a class. The next case, which is the Glanville case that Mr. Sanders spoke of, that was real easy. If there's no damages, there's no individual standing, no class standing. The Chandler case, that's probably the most specific. It's not the right-on case, but it's the specific case that addresses the issue of statutory barring. You read the Chandler case, it's real clear. It says, additionally, the instant claims of the plaintiff against the defendant is barred by the provision of Title 26, United States Code, Section 3403, which provides if the employer shall be liable for payment of tax required to be deducted and withheld under this chapter, and shall not be liable to any person for any amount of such payment. It's the court goes on and says, this statute fairly read states and makes it clear that while we have herein above indicated the employer may be penalized by the IRS. The IRS has a path, they have a statute, they have a way to penalize the employer for not paying and being made whole, because they're injured. The U.S. Treasury is the injured party because they've already given credit to the employee. But it goes on to say, suits against the employees for taxes withheld from pay for such employees is statutorily barred. That's about as right on. There's no division in the court. There's no division at all. The last case that we cited, the Kramer versus David judge, I would just say that basically is this case heard back in 2010. It's right on. These are one of the cases that, when you're doing research, you're really glad to come to, because you don't have to say, well, it kind of means this, so I want you to apply it to this. In this case, Your Honor, we want this law addressing the same issues applies in this case. And it basically says that there's no standing. The plaintiff in our case has no standing, and we don't have to get involved really into the damages issue because it's statutorily barred. If not, Judge, we got 50 states. We got 50 states trying this federal issue. There's going to be some confusion. Likely, there's just you get two people in the room, you may get two different opinions. But in this case, the federal courts and the state courts have been consistent. If you're talking about the same fruit, we're talking about apples, not oranges. We're not talking about contract labor versus employee-employer law. This was specifically employee-employer law, like in J&L Utilities, relationship with the plaintiff. And it, like I said, Judge, it's about as clear as day. Rabbit trails can be made. The good thing is a lot of times the law brings the truth to the top. Judge, what I see is there's a lot of rabbit trails trying to be created. I mean, I've had to enter the case because every person in the family has been sued. Miss Boyd, her brothers and sisters, her grandchildren, her children, even her ex-granddaughter-in-law got sued. The only person that didn't get sued was the dog that was hiding under the porch. If this case, due to the plea to the jurisdiction, that addresses that issue, it's going to quit punishing the Boyd family for standing up for their right on the other case dealing with this buy and sell the business. And like I said, we need to put a stop to the rabbit trail. We don't need to waste court time on this. This thing needs to be booted on the plea to the jurisdiction.
All right, thank you, Mr. Elliott. And so, Mr. Sanders, at the onset, you asked for the relief you wanted was for the court to grant the plea to the jurisdiction in each case, and then if the court did that, then you want the court to set an evidentiary hearing on the issue of sanctions. Is that correct?
The court is inclined to entertain a motion for sanctions, then yes, we'd need an evidentiary hearing on that.
Okay. All right. Is there anything else before we adjourn and I start reviewing?
I'm in both cases, the 136 and the 138, and we've adopted Mr. Sanders' pleadings. We are also asking for both of those cases to be dismissed under the plea to the jurisdiction, and we've also asked if the court should deem necessary or relevant in this that you set us a time for evidentiary hearing on sanctions.
All right, thank you, Mr. Elliott. Anything else, Mr. Leister?
Nothing for me, Your Honor.
Mr. Sanders?
No, Your Honor.
Okay. All right, gentlemen, I'll start working on this today, and the rest of my docket was canceled today, so I'll go ahead and start reviewing and reading. If I can issue a ruling today, I will.
Great. Thank you for your time, Your Honor.
Thank you, gentlemen. You have a great day and a great weekend.
Thank you.